In this class, we've talked about some fairly boring legal concepts like preemption and notice and comment. But all semester long, I've tried to emphasize how these technical legal questions often mask very important, deep divisions in how to address politics and policy, and in fact, they often provide cover for such things. And there's no case that demonstrates this principle better than Department of Commerce v. New York, decided by the Supreme Court in 2019. And this case involves the United States Census, which is conducted once every 10 years and is intended to have an accurate count of all people living in the United States. The census is really important for two reasons. Number one, it's important for purposes of representation. The House of Representatives is apportioned on the basis of population, meaning states with bigger population get more votes in the House. In addition, the Electoral College is also based on representation, and so representation is very important for control of both the presidency and the House of Representatives. It's also important because most federal programs that distribute federal money to the states do so based on formulas in which population plays a significant role. Therefore, states with bigger populations tend to get more federal dollars. So both of these things make the census very important to everybody involved in politics. This case involves whether or not to add a citizenship question to the census. And the citizenship question is actually something that has been very common in American history. In fact, between 1850 and 1950, everybody who responded to the citizenship form was asked about their citizenship. And between 1950 and 2000, at least some of the respondents were asked about their citizenship. So at issue in this case is actually not whether the asking of citizenship is legal or constitutional. It is. That's not the issue. But what has happened over time, the reason why the Department of Commerce has cut back on the citizenship question is that it realizes that it makes the count less accurate. Some families, not an insubstantial number, if there is a non-citizen involved, they are afraid to report that on the form because they believe that that will be used by law enforcement against them. And so the department has decided that they wanted a more accurate count, and since the citizenship question makes the count less accurate, they've decided to drop it. But that all changed when Wilbur Ross became the Secretary of the Department of Commerce under President Trump. And in March 2018, Secretary Ross issued a memo saying that the census in 2020 would include a citizenship question. He said the reason he did this is because the Department of Justice had asked him to do this. The Department of Justice had sent him a request, and that they said that they were interested in improving enforcement of the Voting Rights Act, and that they would like to help increase minority voting rates under the Voting Rights Act, which is what the Voting Rights Act is all about, and that having a citizenship question would help them do that. Now, if you know anything about the Trump administration, I'd ask you to reflect upon that particular justification. We will return to that justification. But nevertheless, that's what Wilbur Ross said in March of 2018. So this is interesting because this touches upon the subject of our previous lecture, the concept of committed to agency discretion. Because the Commerce Department argued that it could not be sued under the APA at all because this action was committed to agency discretion. The court disagreed. They said the taking of the census is not one of those areas traditionally committed to agency discretion. We and other courts have entertained both constitutional and statutory challenges to census-related decision-making. So the second question, though, in the case, and the more important question was, okay, so the court can entertain the case, But the question now is, did he actually abuse his discretion? And as you know from our previous lecture, the government should be able to win cases like this because in such cases the court uses the arbitrary and capricious standard. So Ross's decision could only be overturned if it was arbitrary and capricious. And it's very easy for the government to show that their actions were not arbitrary and capricious. And under this standard, the court asked two questions. Number one, was Ross's decision supported by evidence? And secondly, was his explanation what the court called pretextual? But that's a lie to you and me. So the two questions, was there enough evidence to support his decision? And number two, did he lie about why he did what he did? So the first question, was his decision supported by the evidence? The court ultimately decided yes, it was. They said that, he didn't have to have the best evidence, but he had evidence that there were other ways to make sure that there were no other ways to get the census information, and that there was enough evidence in the record to support the decision that he made. So Ross and the Commerce Department won on this particular point. But it was on the second point. Did he lie, or was his explanation pretextual? The court decided that indeed he did lie. And the record was voluminous. They looked at emails and memos and so on and so forth. And what they discovered was that Ross was determined to add a citizenship question within a week after he was appointed to office. He made this announcement in March of 2018, but it was only 1 week after he got into office that he started asking about, issuing memos, talking about the fact that he wanted a citizenship question. And in fact, he said that the Department of Justice had contacted him because they wanted to enforce the Voting Rights Act, but in fact the record showed that he was the one who contacted the Department of Justice, and that he asked that they ask him to add a citizenship question. And in fact, he invented the whole Voting Rights Act explanation afterwards. There was no evidence at all in the record that the Voting Rights Act and the enforcement of the Voting Rights Act was what they were interested in. And as I alluded to earlier, this was always suspicious because the fact is the Trump administration never wants to improve the voting rights for minorities. In fact, they actively work to suppress the minority vote. And so to say that we want the citizenship question in order to expand minority voting rights certainly didn't make any sense to anybody who pays any attention to the Trump administration. And in fact, again, there was simply no evidence at all in the record that he had done this. So Ross had lied throughout the process in order to circumvent the process. The worrisome thing about this is it was a 5-4 decision. And from my point of view, it should have been a 9-0 decision, because the fact of the matter is this decision should have been about process. We've talked about this all semester long. The APA is all about process, and it doesn't review substance typically. If you follow the right process, then the agency deserves to win in most cases. But in this case, the evidence that Ross had not followed process, that he in fact had lied repeatedly to the court, he'd lied repeatedly to the public, was overwhelming. And so, if the judges were behaving in an ideologically neutral fashion, then this should have been a 9-0 decision. But of course, this was an incredibly political case, and you had a 5-4 decision, and 4 of the justices, 4 of the conservatives, just did not care. They wanted this question to suppress there, because then voting rights, minority voters would be undercounted, which would make it easier for Republicans to win presidential elections and win control of the House. It would make it harder for Democrats to win presidential elections. And because of the political stakes, the 4 Republicans that were on the court simply didn't care. And it's a worrisome decision going forward because it suggests that the 4 Republicans are totally willing to cast aside all principles of law and the rule of law in order to achieve a conservative end. As has happened in the Obamacare case and in other cases, the only reason that the law prevailed in this case was that John Roberts crossed over. He voted with the liberals, and in fact, he wrote the majority opinion. This was a bridge too far, even for him, and so that was encouraging. But of course, if any of the liberals, such as Ruth Bader Ginsburg, who's in her 90s, leaves the court, then you'd probably see decisions like this go the other way. And again, one thing that should unite us all is the rule of law. And in this case, there were 4 justices that simply didn't care about it. Now again, just as I alluded to a moment ago, why is this so darn important? Well, it's important because of, again, representation mostly, but also federal benefits. Of course, conservative states, they want more, as do liberal states, but this is a way to ensure that conservative states get more representation in the House, that they get more chance of winning the presidency, and that they get more federal dollars. In fact, there are few questions that are more important in politics than the question of representation. But again, if we are a nation of laws, this shouldn't matter. So in any case, hopefully you can see the juxtaposition of process and politics in full bloom.